my smile? Hold on. This is like the first time in who knows how long that we've really been able to do this in person. So I'm very excited to start taking pictures. And we're gonna make this a very fun day, fun afternoon with very interesting panels, wonderful speakers. My name is Sherlyn Tung. I am here to, I think, kick off and welcome everyone to we've got to call it's the Generations in Arbitration Conference, Hong Kong Legal Week edition. The GIA is a very long established conference that has been going on for almost 2 decades now. They are sponsored or organized by the Mood Alumni Association. And in the last years, we've had the fortunate sponsorship of Withers Worldwide and, of course, Hong Kong DOJ. So we're very excited to be here today. What I am here to do first is to introduce you to our very special speaker who will be giving a brief welcome. He doesn't really need an introduction because hopefully everyone in this room knows him. Everyone who is online should also know him. Dr. James Ding. He is probably one of the brightest legal minds that I've ever met. Not only in the Hong Kong DOJ, I don't know if I'm allowed to say that, James, so you didn't hear it from me, but I am honest, one of the brightest legal minds I've ever met. But I can tell you his official title, which has changed. He is now the Commissioner of Inclusive Dispute Avoidance and Dispute Resolution Office. So I would like to take this opportunity again to say thank you, James. Welcome, and please give your welcoming speech.
Thank you, Shanine, for your very kind words. Distinguished guests, ladies and gentlemen, it gives me great pleasure to address you at the Generation in Arbitration Conference during the Hong Kong Legal Week 2021. I would like to thank the Mood Alumni Associations for inviting me and for organizing this very important and meaningful event to foster the sharing of views and knowledge on the latest issues in international arbitrations. I note that there will be 2 panel discussions. Panel 1 will discuss why strong legal and judicial systems strengthen rather than weaken international arbitrations, while panel 2 will discuss whether public policy is really only a last line of defense. As a background for the panel discussions later on this afternoon, I would like to share with you some unique strengths of Hong Kong legal and judicial systems and explain why they strengthen the use of international arbitrations as a means of resolving, in particular, cross-border disputes. Hong Kong has a well-established legal system underpinned by the rule of law and the independence of judiciary. Under the basic law, Hong Kong practices common law, which is the same legal systems as the world's major economies and familiar to the international business community. In particular, our legislative framework for arbitrations is very up-to-date and in compliance with the international norms. The arbitration ordinance in Hong Kong is based on the latest version of the anti-child model law, which is well understood by practitioners from both civil law and common law jurisdictions, and also familiar to the international community. Our arbitration ordinance has been constantly reviewed to make sure that our arbitration laws are in line with the latest international arbitration practice. In particular, the ordinance was updated in 2017 to make it clear that third-party funding in arbitrations is permissible in Hong Kong. Provisions confirming the arbitrability of intellectual property disputes and the enforceability of the intellectual property-related arbitral awards were also introduced in the same year. Our legal systems on arbitrations also comprises various reciprocal arrangements between the mainland and Hong Kong. One of the arrangements is the groundbreaking interim measures arrangement signed in April 2019, which enable parties to arbitral proceedings seated in Hong Kong and administered by an eligible arbitral institutions to apply to the mainland court for interim measures directly. Hong Kong is the only jurisdiction outside the mainland which has such an arrangement with the mainland on interim measures in aid of arbitral proceedings. The arrangement has greatly enhanced Hong Kong's attractiveness as a seat of arbitrations and showcase our unique strength under one country, two systems. We also signed the supplemental arrangements concerning mutual enforcement of arbitral awards with the mainland in November 2020 to refine the arrangement concerning mutual enforcement of arbitral awards between mainland and Hong Kong signed in 1999. To further facilitate recognition and enforcement of arbitral awards between the two places, the supplemental arrangements have been fully implemented since May this year. Apart from strong legal systems, Hong Kong has an independent and well-regarded judiciary, which is supportive of the use of arbitrations. The courts in Hong Kong have always tried to ensure that party autonomy is respected in line with procedural propriety. The pro-arbitration approach adopted by Hong Kong courts are well documented in its judgments. Where there exists a valid arbitration agreement between the parties, the court will stay the court proceeding in respect of disputes between the parties in favor of arbitrations. The court also upheld the wide discretions of arbitrators and the flexibility of the arbitration process. Further, there is a special list of judges in the Hong Kong Court of First Instance who deal with arbitration matters. Awards made in Hong Kong have generally been upheld by Hong Kong court, which ensure finality and enforceability of awards. The court in Hong Kong is well known for its enforcement approach as well. In the case of ABNS in 2016, the court has set out the rules adopted towards enforcement of arbitral awards. In summary, the primary aim of the court is to facilitate the arbitral process and to assist with enforcement of arbitral awards. The court should interfere in the arbitrations of the disputes only expressly provided for in the arbitration ordinance. Further, enforcement of arbitral awards should be almost a matter of administrative procedures, and the court should be as mechanistic as possible. In considering whether or not to refuse enforcement of the award, the court does not look into the merits or the underlying transactions and is only concerned with structural integrity of the arbitral proceedings. As such, awards, whether made in Hong Kong or not, can generally be enforced in Hong Kong. The above features of Hong Kong's legal and judicial systems mean that parties do not necessarily have to resort to litigations to resolve their disputes. This is particularly so for parties in cross-border disputes who may wish to avoid litigating in the home court of each other. By using international arbitration as a means to resolve disputes in Hong Kong, they can avoid the difficulties of enforcing the court judgment, since arbitral awards made in Hong Kong are enforceable in over 160 jurisdictions under the New York Conventions and also under our relevant arrangement with the mainland and Macau. In gist, our legal and judicial systems support and enhance the use of international arbitrations for cross-border disputes. On the subjects to be discussed in panel 2, I will briefly mention that the Hong Kong Arbitration Ordinance provides for refusal of enforcement of arbitral awards under public policy ground. However, consistent with the pro-arbitrations and pro-enforcement approach adopted by the courts tend to apply the public policy in a very restrictive manner as shown from our case law. For example, in the case of Gao Hai Yan and others, in 2012, in determining whether a private meeting over dinner as part of the mediation arbitration process outside Hong Kong would render the arbitral award concerned tainted by bias or apparent bias, the Court of Appeal reiterated the important principle that the enforcement of an award should only be refused if enforcing it would be contrary to the fundamental conceptions of morality and justice in Hong Kong. By showing respect for the usual way of conducting mediations in the place where the mediation took place, the court found that there was no apprehensions of apparent bias based on the facts and refused to invoke the public policy ground. Solely because the mediations was conducted differently from the usual way that it will be conducted locally. Indeed, the issue of whether enforcement of arbitral award will be contrary to public policy is not taken lightly by the Hong Kong court. The Hong Kong court only set aside an enforcement order for arbitral award based on public policy grounds in very exceptional and clear cases. I'm sure that the speakers today will continue to share with you more in-depth discussions on the applications of the public policy grounds on the enforcement of arbitral awards. And we'll also further elaborate on how and why strong legal and judicial systems will strengthen rather than weaken international arbitrations. On this note, may I wish you all a fruitful conference, and I wish the conference every success. Thank you very much.
Apparently, I'm going to be your MC today, so you're going to see a lot of me. I'm also going to moderate your second panel, so I hope you don't get sick of me. I actually would like to take this opportunity now to introduce the moderator for our first panel. I should probably remind you what our first panel is, but thank you, James, again for giving such a brilliant welcome and for taking the time to give us the welcome. Moving on to the first panel that James referenced to, the first panel is Hand in Hand: Why Strong Legal and Judicial Systems Strengthen Rather Than Weaken International Arbitration. I'm not going to elaborate on the panel because I have a wonderful moderator with an amazing panelist or panel of speakers who will do that for me. So Joanne, may I ask you to please come up here, I think also with your panel. I'm not too sure how that worked out, but they're gonna sit here. We've got a hybrid event today, so you're gonna have some people in person, some people online. You'll see them all, don't worry. But introducing Joanne Lau, who is a partner at Allen & Overy here in Hong Kong. She's a partner in the international arbitration practice, and I would assume the international disputes practice. And Joanne is also the co-chair of Hong Kong 45. She is very well experienced in international arbitration proceedings under various institutional rules, and she also acts as an advocate for these arbitration proceedings. We're very happy to have her, so if I could have you come up, please, and I will switch. Oh, there they are. Sorry. Okay, I'm gonna go now.
Hello. Hi, everyone. Very happy to see all of you here. And thank you very much to Charlene for the warm introduction and for organizing and inviting us to this amazing event. As Charlene mentioned, my name is Joanne Lau. I'm a partner at ANO's International Arbitration Group. It's a pleasure to be here, and it's a pleasure to be joined by such a distinguished panel. So with me here today in person are Melody. Melody Chan is a partner at White & Case Hong Kong. And we also have here Joseph Chu, who is a partner at Withers, also based in Hong Kong. As a proper hybrid event, we also have panelists who are joining us virtually from different parts of the world. We have Ambassador David Hubner, who's now an independent arbitrator based in the United States of America. And also Ms. Amy Klasner, who is a partner at Jones Day based in Frankfurt. So thank you to all our panelists for being here. Today's topic is hand in hand: why strong legal and judicial systems strengthen rather than weaken international arbitration. And I think that's a very, very interesting topic. because when we talk about international arbitration, very often people describe that as a dispute resolution method that is outside of the court system. And when we talk about pro-arbitration jurisdictions, we sometimes hear of principles of minimum judicial interference. But at the same time, in practice, situations arise from time to time where parties do need to go to court for judicial assistance, either at the start or during the arbitration or at the enforcement stage. So what we hope to explore today is that interplay between the judicial system and the international arbitration regime, and to see how legal system, judicial system support international arbitration, and together, hand in hand, how they complement each other. So with that, I think we'll launch straight into the panel discussion. We would very much welcome questions, both from our audience here today, or for those who are joining us online. I understand there is a Q&A function on Zoom, so please do feel free to submit your questions, and we'll try to address them either along the way or towards the end. So let's begin. I want to start, first of all, from the very beginning on choosing the seat. And my first question is for Melody. In your experience, how important is the pro-arbitration stance of a jurisdiction's legal and judicial systems for parties when they are choosing their seat of arbitration? And a related question is, what factors do you consider in determining whether a jurisdiction is pro-arbitration or not?
Thank you, Joanne, and thanks everyone. I should take this opportunity to thank you, the organizer, for inviting me here. It's a pleasure to be here, and it's great to see everybody in conference mode. Turning to Joanne's question, I would first start with saying that it's indeed very important. I'm not just saying it because that's the topic for today. I've actually come with some empirical studies results. So in the latest 2021 Queen Mary University of London White & Case arbitration survey, we've actually taken responses from a lot of people, and that's exactly the question, one of the questions that we've asked them. Firstly, as a method of disputes resolution, it's not surprising that arbitration is one which is very much favored by users when we are talking about cross-border transactions and any disputes arising out of that. Then we delve a little bit further into that. Okay, you're choosing arbitration as your preferred method of dispute resolution. Which seat are you going to choose? And from that results, the survey results shows us that a couple of very well-known jurisdictions, London, Singapore, Hong Kong, all of those are the top jurisdictions in which parties are choosing as the seat of their arbitration. Obviously, then we ask the question, why? Why do you choose these jurisdictions? What's so special about these jurisdictions? It's probably not surprising that the legal trades, the legal system, and in particular the court system that all of these jurisdictions have in common, they have a very strong court judiciary support. So when we then ask our respondents, if we were to change something, what sort of adaptations for other seats that you would be hoping to see to make other seats more attractive? And the answers that we got are actually extremely on point for today. 56% of participants, respondents, said they need to have greater support. They want greater support for arbitration by local courts and judiciary. Importance of courts and judiciary. 54% said increased neutrality and impartiality of local legal system courts. 47% says a better track record in enforcing agreements to arbitration and arbitral awards, again, involving the courts. So all of that are very strong factors indicating how important the court, local courts, the judiciary is in terms of arbitration and how it's supported. I think the second question you asked me is, what would I consider as a pro-arbitration jurisdiction? I think we need to all step back and think about what arbitration is, and I think Joanne mentioned that as well. It's a way of disputes resolution, but more importantly, it's a privately agreed way of disputes resolution. So if the parties have decided to choose arbitration as their way to resolve disputes between them, they would want to have their choice respected and supported. And as a result, that's the reason why it's very important if the local courts that these parties are at, the arbitration is seated, if they are supported of this choice, if they are supported of any arbitration agreement chosen by parties, it's very important to them. So to me, a pro-arbitration jurisdiction will have to be very strong and very supportive of arbitration in various matters. That would include their willingness to grant anti-suit injunction, whether they will be willing to uphold parties' arbitration agreement, the support these local courts will give in support of arbitration, and lastly, but probably very important, is the stance the court will take when there are applications to set aside awards or when there are applications made in enforcement of those awards. I believe we are going to deal with all of those questions today.
Thank you, Melody. That I think is an excellent start of our discussion. And indeed, it's really interesting to hear so many survey participants touch on legal systems and judicial systems and have desires on what those systems should look like to strengthen international arbitration. One very good point that the survey participants also touch on, as Melody mentioned just now, is they want to see a better track record of local courts in enforcing agreements to arbitrate. And that ties in nicely with my next question, which is one for Amy. I want to get your thoughts, Amy, on what role do the national courts play in upholding arbitration agreements and avoiding proceedings commenced in breach of arbitration agreements?
Thanks very much, Joanne. So I'd like to use the image of the good parent. Courts are, of course, national courts are strong, they're respected, established, and powerful. So what can courts do, or what should courts do for essentially the child arbitration? And I'd say there's really two phases. So at the beginning, like a good parent, the child arbitration will need a lot of support. It's not able to really act on its own at all before we have an arbitral tribunal installed. So at the initial stages, we need attentive care. We need quick and responsive action by the courts to appoint arbitrators where the parties have not themselves appointed, or where the arbitration agreement provides for court appointment. And then there can be appointment difficulties, of course, challenges. Again, then we need swift action to sort of get this child on its feet. And the third way that surfaces is also in relation to arbitral challenges to arbitrators. So we need, again, the swift and decisive support of the courts there. Another way that sort of a young arbitration can really be endangered is by parallel proceedings in courts. So we need courts to dismiss parallel proceedings, to enforce arbitration agreements. And this involves taking really rather a liberal stance towards arbitration clauses, interpreting them liberally, giving effect to the party's desire to have this privatized system of justice. Whether or not the courts go so far as to issue anti-suit injunctions, that's sort of a matter of style. Obviously, we have jurisdictions that will go to that length, in particular some of the common law jurisdictions, and many other jurisdictions, though, that consider that inappropriate. But what happens after the arbitration is sort of initially established, it's got its arbitral tribunal in place? That's where we need that good parent to kind of step back and give the arbitration its independence. In the UNCITRAL model law, we have this sort of limitation on court interference or court support. Interference or support really depends on your perspective. But the court should only act in those enumerated instances where, where it's required and where it's allowed. And finally, we'll get to these later on in the sessions. If the arbitration needs some help, so with interim measures, then the court should step in and help them, but they shouldn't really micromanage or get involved otherwise. The final point I've raised is simply none of us are born knowing how to be the perfect parent. It's really learning by doing, and as the times change, in particular, parents also have to keep evolving and learning. And arbitration is a really young discipline. It's evolving very quickly. So there's a steep learning curve. And how does a good parent sort of cope with that? They really should talk a lot to their child. They should talk to the arbitration community, engage in a dialogue. So exactly the type of conference and dialogue we're engaged in today. This is critically important to keep the courts abreast of developments, to ensure they're really understanding some of the complicated concepts such as separability. How do we really deal with that? And again, arbitration clauses, understanding how they work and understanding that they can trust the arbitrators to then take over.
I can just want to add on one point that Amy was talking about, how having a good parent is very important. I think it's also very important to have experienced parents. One of the things, last year, the end of last year, we were, as a firm, we were doing an anti-suit injunction before the Hong Kong courts. And it's absolutely wonderful that when we go before the court, and the judge is well versed in arbitration. Some of the points that Amy talked about, separability, importance of arbitration agreement. In order for us to get our proper relief, we actually do need to have judges who are very well versed in all of those ideas. So I think as a good parent, you need to be kind of experienced as well. And I totally agree with what Amy was saying.
Thank you, Amy and Melody. I think that's the first time I've heard of this analogy, the parent-child relationship. But I think that's a very apt description, and so it's a very, very, very interesting. Thank you for that. And Amy also touched on it just now, saying to enforce and uphold arbitration agreements. Sometimes courts need to have a strong hand in knowing they need to stay parallel court proceedings which are commenced in breach of arbitration agreements. But my next question touched on a trickier area where things are less clear-cut. In many jurisdictions, including in Hong Kong, there are discussions from time to time about this tension between the insolvency or bankruptcy regime and the arbitration regime. And it is not often clear what should be properly dealt with by the national court and what should be dealt with by an arbitral tribunal. So I was hoping our panelists could share their views on how this line is or should be drawn. So maybe let me start with David.
Thank you. I'm delighted to be here. I'd like to say, in particular, thank you to the organizers of the event, particularly to my friend Sherlyn. I have to say, Sherlyn is the only person I know who could persuade me to comb my hair and smile into a Zoom camera at midnight here in Los Angeles. I wish I could be with you all in person. If I could slide back briefly to a prior question, I agree with everything that's been said about the importance of selecting the seat. Having been a party as well as counsel and now an arbitrator in arbitration, I would also suggest be very focused on the infrastructure and cost as you select your seat. The most interesting case I encountered as an advocate called for Maui as a seat. The case ended up settling once the parties realized the cost of trying to create the infrastructure for a 4-week hearing on Maui, which is not known for its arbitration infrastructure. In terms of the question posed by Joanne, there's no easy answer on insolvency and bankruptcy. Sometimes it's very location specific. For those of you who are arbitrators, you don't need to know the answer yourself. The best friend of the arbitrator is called the briefing schedule. And if something involving bankruptcy or insolvency arises in your case, the first thing you should do is set a briefing schedule and solicit submissions from your parties. Having said that, I've had 4 of these in recent history, 4 cases in which a party put itself into bankruptcy or insolvency. In 2 of the cases, courts attempted to stay the arbitration. In one of those 2 cases, I proceeded because the court attempting to stay the proceeding was not a court at the seat. In another case, it was a court at the seat, but I did not immediately self-stay. I solicited briefing from the parties, and the tribunal then reached a decision that the prudent approach was to suspend the arbitration pending further word from the parties about the proceedings. The 2 most interesting of the 4, though, involved courts at the seat, but courts which did not immediately attempt to stay the arbitration. You will often find that there is a trustee appointed who makes an appearance through counsel in the arbitration, which then gives you a chance as an arbitrator or a party counsel to have a conversation about how to efficiently structure a process. And in those 2 cases, what ended up happening was the bankruptcy courts deferred to the tribunal on the establishment of a factual record and the reaching of conclusions on points of law other than points of insolvency law, thus reserving to themselves, based on the record established by the tribunal, the right to make decisions on bankruptcy allocations within their legal purview. So in those 2 cases, it was an interesting hybrid because neither side did an abrupt either attempt to stay or a self-stay once there was a filing.
Thank you, David. I wonder if Melody, you could also comment on this a bit, because I know in Hong Kong we have competing case law, so it's a very, very topical issue here.
Yeah, yes, indeed, Joanne. I think David was kind of talking about from an arbitrator's or from an arbitration perspective how bankruptcy or insolvency proceedings could affect the arbitration. We've actually looked at it from another angle, which is how courts are looking into arbitration agreements. Because obviously the parties, they have agreed to an arbitration agreement and they should have submitted all the disputes between the parties to arbitration. But sometimes creditors would take advantage of the fact that, if to the extent that it's a money debt that's rather straightforward, they would probably take advantage of that and decide to just simply go to the local courts and try and start some insolvency proceedings against the debtor. So in that case, despite the arbitration agreement, they can kind of get around that and just go straight to court and seek a winding up order or bankruptcy order. So we've actually looked into that from different common law jurisdictions. The traditional approach is, as winding up insolvency, bankruptcy proceedings, these are class action remedies. And as a result, the court's general approach has been, this is something which is not to be privately agreed with. And as a result, to the extent that there are grounds to proceed with an insolvency or winding up proceedings, they will do so. But I think with the rise of arbitration, and again, with more and more national courts taking a more pro-arbitration stand, the jurisprudence on that has definitely been developing quite a bit. Joanne mentioned the conflicting decisions. There are decisions in Hong Kong where Justice Harris has kind of followed the English approach, saying that we should, to the extent that there is an arbitration agreement, we should respect that and stay or dismiss the winding up petition while waiting for the arbitration to be resolved. But then there are subsequent Hong Kong case law which suggests otherwise, and you would need to prove that you actually have a proper dispute before you can refer the matter back to arbitration. The situation in Singapore is kind of similar. Same thing with BVI and Cayman, that with the very popular offshore jurisdictions, is not very clear. There's a trend that you can or you cannot stay. So again, I think unfortunately we probably has to go to the different jurisdiction, as David was saying, is probably quite jurisdiction specific.
So I guess in Hong Kong, it's watch this space. So it's still a developing area. The next question I want to turn to Joseph, and to change the topic a little bit. Both Amy and Melody touched on interim measures just now as another feature of what judicial systems could offer in support of arbitration. At the same time, I know arbitral tribunals also have the ability to grant a wide range of interim relief. And in recent years, institutions have also introduced emergency arbitrator provisions, which again provide another forum for parties to seek urgent interim relief. So I want to get your views on the following question, which is, despite the ability of tribunals, which can provide interim measures, why is the ability to seek interim relief from national courts in support of arbitration still important?
Thanks, Joanne. I think there are essentially three reasons. I mean, the first reason is, notwithstanding the emergency arbitrator provisions is available, it's still much quicker to seek the relief from the court. I mean, under the HKIAC emergency arbitrator procedure, then you can have the emergency arbitrator appointed in 2 days. They make decision within 15 days. It's already very quick. But courts in Hong Kong are even quicker. In cases where it's really urgent, you can actually get an injunction from the court within 48 hours. So when a party actually is facing the risk of assets being dissipated or evidence vanishing, I think 1 day, 2 days would make a world difference. So that I think is one of the reasons why relief from national court is still important. Another reason is that the relief from national court is actually more directly enforceable. You need to go through a two-step procedure if you want to enforce an order from emergency arbitrator. You need, first of all, to appoint the arbitrator and then get an order from them. And then with the order, you need to apply to court for leave to recognize the order before you can actually enforce it in Hong Kong. So this procedure takes time. And on the other hand, court actually, if you're able to obtain relief from the national court, those orders can be immediately enforced. So that's the other reason. The third reason is that, given the consensual nature of arbitration, the arbitrator has no power to grant any order against any non-parties. But court is different. I mean, court can grant interim relief against parties that are not to the litigation. So that's another advantage of seeking relief direct from national court rather than from the tribunal or from the emergency arbitrator.
Thanks, Joseph. Yes, that's very on point. I think as arbitration lawyers, very often we think of what can we do in the arbitration, what can we get. But you raised an important point, which is if you want something directly enforceable, sometimes you also have to consider your various options from that angle and to assess whether relief from the tribunal would be sufficient, or whether in particular set of circumstances going to a court would be more helpful. And I know one interesting development, which James also touched on in his introduction, is the groundbreaking mainland China, Hong Kong interim measures arrangement, which is also on the topic of interim measures. I don't know if one of you want to.
I was hoping to mention that, but I think James already made a fairly detailed description of it. But I'll just add one point. I think there's some statistics. The arrangement came into force in October 2019. It's now 2 years. It has been used by many users. So there are a total of 53 applications made, and the amount of assets freezed by mainland courts is $2.3 billion US. So that actually is one of the empirical evidence to show the importance of the role of the national court in granting interim relief, because actually we are using it.
Yes. Yeah, also in my practice, I think that has made a real difference in China-related transactions. Picking Hong Kong's seat has this additional advantage now going to PRC courts for interim measures, so a very positive development. Aside from interim measures, national courts also play other role, including in securing evidence for an arbitration. Turning to David, I know there have been some interesting cases in the US on this, and I wonder if you could share more.
Absolutely, thank you. It is important if you're working in a particular seat to track what the current issues are in front of the courts. Here in the United States, there have been 3 particular issues I've been tracking. One of them is of particular interest to me, which is the power of tribunals in cross-border disputes to seek evidence from third parties not in the arbitration. It's been a significant controversy here in the United States. We are a federal system divided into 50 states, which are comprised into 11 circuit courts. 4 of our circuit courts have held, including here in California, that a tribunal may not issue subpoenas seeking evidence from entities not party to the arbitration. We have 3 circuits that believe such subpoenas to be appropriate under the Federal Arbitration Act. The US Supreme Court was set to consider the issue this year, but the 2 parties settled their case. So the issue remains open. So if you are planning to arbitrate in a part of the United States, you should be looking at which circuit court your seat is in to see whether there is this ability to subpoena evidence from third parties. Just briefly, there are 2 other important issues that are of larger, I think, applicability and interest. One is the very important issue of whether non-signatories can be made proper parties to arbitration. Here in the United States this year, that issue was settled by our Supreme Court in the GE Energy Power case, holding that yes, non-signatories can be made by the tribunal parties to an arbitration if there is, under the law selected to be applicable to the arbitration, provisions in that law that would make the joinder of the parties appropriate. Finally, there is always an issue around arbitrability. Whose decision is that? Is that the decision of the courts and the seat of the law, or is it a decision of the tribunal? I had been hoping that would be finally resolved this year. There is a case, the Henry Schein case was before the court. The court dismissed the case on a procedural issue unrelated to arbitrability, so that remains open. And in particularly the issue to watch is a provision in the rules of an institution that provides that arbitrability is reserved to the tribunal. If the parties select those rules in their agreement, is the imputed decision on arbitrability through the selection of the rules binding on the parties? Here in the United States, that issue is still an open one because of the dismissal of the Shine case.
That's very interesting, and it sounds like there are some very powerful tools which the U.S. courts could use too. So thank you for that sharing. So just now, the past few questions, we touched on judicial support during an arbitration. I want to move to a slightly different section now. So assuming the arbitration process is done, we reach the enforcement stage of an arbitral award, and we can now look at what judicial support there is. I will go back to you first, Joseph. I wonder if you can share any interesting case law highlighting the court's approach in the enforcement of award, or any cases illustrating limited grounds of refusal of enforcement?
Yes. I will mention one case called C&D. That's a case in Hong Kong. That case, in summary, the court rejected an attempt to set aside an Hong Kong arbitration award on the basis of an alleged jurisdictional point. Now, what happened in that case is this. There's a contract. It contained a multi-layered dispute resolution clause. And one tier said you need to have negotiations between the CFO of the parties before you can actually commence arbitration. Now, no such negotiation took place, and an arbitration was commenced. And eventually, an award was issued against one party called C, and in favor of another party, D. C obviously is not happy, and then applied to the court in Hong Kong to set aside it. And the argument the party made was there was a condition precedent to the commencement of arbitration was not satisfied. And therefore, the tribunal does not have jurisdiction to hear the case. Now, under the New York Convention, an award issued by a tribunal is final, and the court would not be allowed to review the substantive merit of the case. It can only set aside an award on very limited grounds. For example, breach of due process or lack of jurisdiction. So the question for the court in that case is whether the failure to satisfy the multi-layers dispute resolution clause is actually deprive the tribunal of its jurisdiction to hear the case. So the court ultimately said no, so basically, and dismissed the application to set aside, and said, look, the failure to satisfy the condition precedents has nothing to do with the jurisdiction of the tribunal. And the court said, it goes to the admissibility of claim. So whether a claim is admissible is entirely a matter for the tribunal to decide. And as the supervisory court, in that case, Hong Kong, basically have no power to review the merits of the case. So that case is interesting in the sense that actually many petitioners in Hong Kong used to assume that if you fail to comply with the multi-layer dispute resolution clause, it's a very important matter, and it actually goes to jurisdiction of the tribunal. And I've actually seen parties making this, relying on this the same argument, and raise a jurisdictional challenge in the arbitration itself. But this actually clarifies the law, at least in Hong Kong, to the effect that, look, a failure to comply with the condition precedent to an arbitration is important, but it doesn't go to the jurisdiction of the tribunal. And that's the case I want to mention.
And turning to Amy from a civil law jurisdiction, can we hear from you too on whether there are any interesting cases from your jurisdiction on enforcement of award or challenges to enforcement of award?
Sure. I'd like to mention two examples. Harkening back to what Joseph just said, I would say there the courts placed substance over form. The two cases that I'm going to address are, I think, where the courts have gone a bit too far and really placed form over substance, and have been holding arbitrations and arbitrators to an extremely high standard, and perhaps a standard that is not really realistically achievable. So the first case I'll just mention is from France, which is, of course, a very renowned seat of seat of arbitration. The case involved an ICC arbitration in the automotive sector, SBA versus Volkswagen. The award was set aside in France in 2018, 2019, and went through the appellate process. And the award was set aside. The situation was the following. This involved composition of the arbitral tribunal. One of the party-appointed arbitrator was in a mid-sized national firm. The firm had, and the other side, essentially after the award had issued, read in our local, in Germany, our local legal rag, we call it Juve, that there's a newsletter every day, and they have rankings and a handbook. And we all, of course, try to, it's, sort of like the local version of Chambers or Legal 500. We all try to, provide information to Juve, of course, in an appropriate way. But ultimately what Juve writes, we don't have control over it, and it's not necessarily always perfectly accurate. In any case, the situation was that this arbitrator said he was completely unaware that someone in his firm had billed euro 7,520, so a fairly small amount, for a group company related to Volkswagen. That he was surprised, in fact, when he read about this in Juve as being one of the firm's headline mandates, and that was actually not the case. The court, though, again, held that arbitrator to this extremely high standard and said, even if that was mistaken, and there was evidence that it was mistaken, and even though the arbitrator said he was himself completely unaware of that very small representation, the award was set aside. The second case I'll mention involves Germany, another, let's say, up-and-coming seat of arbitration. This involved procedural due process. So this is the so-called AGFA case. It involved, it's a very, very long case. It went on, over many stages for, literally 10 years. Finally, an award issued after many, many difficulties. And that award was set aside in January 21. That was a 2018 award set aside in January 21. The case was technically a domestic case, but its reasoning was then immediately applied by parties to an international case. And even though it was domestic in name, the case actually had an international character. Bottom line, what the court did is the court combed through, even though a court is not supposed to revisit the substance, they combed through all of the evidence and the lengthy expert reports and concluded that the arbitral tribunal had failed to consider and, quote, intellectually process a particular aspect of the evidence, and that this failure to have considered and intellectually processed, as evidenced by the words they wrote in the award, right, constitute a violation of the right to be heard. And this is significant, obviously, because if we think of arbitration cases, they're frequently very, very large, very, very complicated, involve reams of expert evidence, frankly, often on a scale that national courts do not face or would be unfamiliar with. And this court was holding that arbitral tribunal to the standard of literally addressing every single point that had been raised in witness evidence or in expert evidence. And as I said, there's currently pending, and we expect the judgment in November of this year, a case Lixel versus AIG. This is one of the a huge post-M&A case, but involving actually a warranty and indemnity insurer. And the same argument was brought, namely that the arbitral tribunal had ignored or failed to consider and intellectually process and express that in the award a certain aspect of the witness evidence. So the lesson learned here is, arbitrators can be held to this extremely high standard and really need to cross every T and dot every I and really go through all of the evidence and, demonstrate or prove that they've intellectually processed it. And I think critically, you could say that that's almost an impossible standard.
Thanks, Amy. I think these examples of successful challenges to awards are like horror stories for arbitration lawyers, parties, and arbitrators, especially when awards enforcement is refused on things which prioritize form over substance. So things which—
If I could just give the conclusion of the horror story, the horror story has not even ended for the arbitrator in the first case that I mentioned. He's namely being sued in France for damages, for having basically caused this award to be overturned, and now having the new costs of a new arbitration. So it really is a horrible story.
Yes. And maybe staying with you, Amy, and I'll be interested in your thoughts too, David, given all of these, do you have any tips or strategies you could share which are available to prevailing parties, to maximize their chances of successful enforcement in local courts?
Sure. So from a counsel's perspective, really this starts already at the drafting stage, when we're even choosing arbitration and drafting our contracts. First piece of advice: avoid, complicated conditions to arbitration. You may have some clarity on that in Hong Kong now, which is wonderful, but many other jurisdictions that can still be a problem. Define the scope of arbitrable disputes clearly. Does it only extend to contractual claims or also related or ancillary tort claims? I've seen jurisdictional disputes about that. And those jurisdictional disputes can, of course, resurface in the context of set-aside or recognition and enforcement. Third, specify the law applicable to the arbitration clause. I wouldn't have said that, if you'd asked me about a year ago. But as we've learned now from the ENCA decision, and there was a recent subsequent decision from the English courts on that same topic, there is a real divide among nations now, in particular France and England, on what law is applicable to the arbitration clause, and that again can then affect a lot of other issues and generate grounds for set aside at a later stage. So I'd say nowadays, really, it just makes sense to include it. And then avoid complicated requirements on arbitrator qualifications or very strict limits on the duration of the proceedings. So kind of don't micromanage it in advance, because all of those requirements that you put on the arbitral tribunal can then, if they're not fully upheld, can be then cause for set aside. Seat, obviously choose an arbitration-friendly seat, and we've talked about that, so I won't go into detail. And the last point I'll raise on this drafting stage is internationalize the dispute. The set-aside I just mentioned in Germany regarding procedural due process was technically a domestic dispute, and the court even raised an additional ground that they didn't end up relying on, namely that there had been a dissenting opinion by one arbitrator, and they said the existence of a dissenting opinion, at least in a domestic case, would violate public policy, because it opened the door to the arbitrator's deliberations, and that would be a sort of a sacred precept under German court procedural law that judges should not do that. So you want to, as even though the UNCITRAL model law is often applied equally to domestic and international arbitrations, it really can make a difference whether you're domestic or international in many jurisdictions at the enforcement stage. So internationalize it. And this sometimes is difficult. If you have two multinationals but they happen to be seated in the same jurisdiction. They're doing it like maybe even a global transaction, but technically it's two national parties. You'd be domestic. Or many regimes have nationalization requirements. So if there's a joint venture, for instance, the entity involved needs to be a local entity. Again, that can cause you to fall under a domestic regime. So choose an international seat, perhaps even those two domestic parties, maybe they go to a third jurisdiction to arbitrate, or involve an international party, as a guarantor, or internationalize the performance, because you really are safer under the international regime. And then at the dispute stage, again, you want to be thinking very strategically. As soon as the dispute arises, where is enforcement most relevant? Where is the money? Where are the assets? That's ultimately what the client wants. They want to collect. And if those assets are in a particular jurisdiction, you're going to want to ensure that your counsel team has, that sufficient procedural knowledge to anticipate any potential grounds for refusal of enforcement. And that may even influence your choice of arbitrators. To sort of ensure that the arbitral panel includes someone among them with knowledge of or sensitivity to that jurisdiction's set aside or refusal grounds. And finally, I'll just say, with the lesson learned for me from the case from France with the arbitrator conflict is courts may hold everyone in the proceeding to a very high standard. And counsel can really and should really play an active role in fleshing out any potential conflicts. In particular, where we have arbitrators, in small firms or middle-sized firms that may not have very sophisticated conflict management systems, where you have changes in the counsel team, law firm mergers, lawyers changing firms, arbitrators changing firms, global parties with big groups of companies. You can develop ways during the arbitration, in regular intervals, kind of reminding everybody, to redo a check, to make sure before any of those changes happen that you've got agreement on what's going to happen. That's I think just the necessary work that we now need to do to avoid set aside or refusal of enforcement on a ground that may not even really be a substantive ground.
Those are very good tips. And maybe let's now turn to David, and especially because I know, David, you sit as arbitrator. So you could perhaps also share some thoughts from your perspective as arbitrator.
Certainly. Thank you. Just a couple of footnotes to Amy's excellent recitation from the counsel's perspective. Having been a counsel for many years before becoming a full-time arbitrator, I would say be very creative about your search for assets against which to enforce. The best money you're going to spend as counsel on behalf of your client is not necessarily for you, because we assume you're going to win the case. It's for the investigators to look for the assets and be creative. In a couple of cases involving state entities, what I ended up doing was actually using local processes to arrest aircraft. So it's not just cash, it's aircraft, it's accounts receivable. Think about where you're going to find what it is you need to fully satisfy. Number two, be sensitive to intellectual property. The bulk of my cases, both as an advocate and now as an arbitrator, involve IP in the technology or telecom or life sciences sectors. I have seen arbitrators write awards that cannot be enforced because the party which prevailed would not want that award on the public record, given how the arbitrator dealt with intellectual property. You want to be sure that the arbitrator is sensitive to what can and cannot be actually written in the award if you're dealing with IP. Now, putting on my arbitrator hat, your job as an arbitrator, and I know many in the audience either are or would like to be arbitrators, Your primary function is to render an enforceable award. Full stop. You're paid to render an enforceable award. As counsel, I always wanted you to get it right, but quite frankly, right or wrong, your job is enforceable award. You do that by being very careful to articulate your thought process, including on procedure. The most important part of your award is your procedural history. You want a reviewing court, an enforcing court, to be able to read that section and form the independent conclusion that the parties were given a full and sufficient opportunity to be heard, and that you exerted your discretion appropriately. In fact, often the procedural history section of my awards is the longest section in the award. Number two, you will encounter, whether as counsel or arbitrator, non-appearing parties. That's not an easy situation. You should not be happy about that, because the non-appearing party situation complicates enforcement. As an arbitrator, you need to be very clear that you're not rendering what would be considered a default award. You need to be very clear that you probed the evidence, you tested the evidence, and you reached a conclusion not based solely on drawing inferences from non-appearance. I've had several of those cases, and I always insist on a hearing. The party that is appearing will not want a hearing. They will want to reduce their expense and submit on the papers. I never allow that. I always insist on a short hearing so that as the arbitrator, can hear their witnesses and test their witnesses or read their witness statements, but still have the opportunity to probe the witnesses, so that on the face of my awards, there is a basis for me making judgments on credibility and evidence, not simply because one side did not appear. There are a variety of other issues, but I won't go on any further other than to say it's particularly important in such an award, if there's a non-appearing party, to identify something that Amy referenced, which is to expressly state in your award that the contract was a commercial contract and that the dispute is a commercial dispute within the terms of the New York Convention. So that again, you're making it clear on the face of your award what you're doing and what you've done. Sometimes, knowing lots of judges, I have great respect for judges. I think sometimes we overestimate the amount of time they have on their busy dockets to review documents. You need to write your award so that somebody who knows nothing about your case in 5 minutes can reach a conclusion that you were fair and that you reached the correct result.
Thank you. Quite a challenging role for arbitrators, but all of those points are very important ones indeed. Many in our audience would be interested to hear more about enforcement of arbitral awards in the PRC. Melody, any observations you could share on the ease of enforcement in the PRC?
Sure. I think, obviously, I'm not a Chinese lawyer, but in terms of kind of advising clients and kind of working in that field, and I'm pretty sure a lot of us here will know the increasing impressive track record of enforcement of arbitration award in China. It's certainly something that's very encouraging. I think that is very much on point of what we are discussing today. The fact that the local courts are supportive of arbitration, are willing to enforce arbitration awards, are willing to respect awards that's been granted in an arbitration out of the jurisdiction is indeed very important, and goes back to what I was saying earlier, that with that support, parties are more willing to choose those jurisdiction as their seat of arbitration. Again, quoting the QMUL results, I think this year's is very interesting. Apart from your traditional London, Hong Kong, Singapore seats, Beijing and Shanghai also came up as one of the top 10 seats that's preferred by parties. And you know, as I've said earlier, that's not surprising with the current system that's been in place in China to ensure that arbitration awards are being properly enforced. So I think, as you probably will have heard, there's a reporting system within the Chinese judiciary to the extent that when you enforce an award, obviously you have to go to where your respondent is situated and where their assets are, and that can sometimes be a local jurisdiction in a small city within China. There's always been a lot of criticism about protectionism, about the judiciary being biased to local players, and to relieve that and to ensure that this will not happen, the Chinese courts have put in a system where, to the extent that the local courts are refusing to enforce an award or trying to set aside an international award, they have to report to an upper, higher level of the People's Court. And to the extent that the higher People's Court is not willing to enforce and consider that there should be a case for set aside, that will have to eventually go to Beijing, the Supreme People's Court, for decision. So that process in itself has really helped in improving the track record of China in terms of enforcement of international arbitration award, and also gives a lot of comfort to a lot of us here and also around the world in terms of enforcement of award in China. So again, it's not surprising that with following the accession to the New York Convention in the 80s, the Chinese courts have been building up its reputation and also building up its infrastructure. That has really helped everybody in terms of enforcement and also in terms of promoting Beijing and Shanghai as seat of arbitration.
That's very encouraging to hear. So again, a very positive trend there. Turning to the last section of this panel discussion, I want to look into the future. So my next question is, and maybe I'll start with you, Joseph, is what are some changes that you would like to see to further enhance the use of international arbitration?
Thanks, Joanne. Organize my thoughts first. Well, I would hope the arbitration would be quicker, greener, and more transparent. So I actually have 3 points on my wish list. The first point, obviously, is about the speed. So I'm hoping there will be a procedure for early termination of dispute in the arbitration. I think this has partly achieved because a number of arbitration institution has already introduced rules for early termination of claims. I'm hoping that this could be codified actually in our law, such that all Hong Kong seat arbitrations will have the benefit of resolving disputes efficiently by using this summary procedure. The second is to make the arbitration greener. So in many cases, particular arbitration cases, it involves a lot of documents, and it involves witness around the world. So for arbitration hearings, a lot of travelings will be required. A lot of papers will be consumed in the process. But last year, I think we have seen, COVID to prevent people from traveling. We have been using virtual hearing, we've been using digital bundles. I mean, this actually saved a lot of money for the parties and for the tribunal. And it's actually make the arbitration greener. So I'm hoping the use of technology actually can form part of the DNA of the arbitration. And a greener and cheaper arbitration will help attract more users. So that's my second point. The third point is to make the arbitrations more transparent. I think there's some institution already published some of the redacted awards. and develop their own arbitration jurisprudence. I think that jurisprudence would be very useful to users because recent decisions on certain procedural matter actually will help us understand. So how this particular rules should be interpreted and should be applied by the tribunal. And that also increase the credibility of arbitration as well, because that people know that cases are being fairly adjudicated, so that people actually can see justice being done in the process. So that's the 3 items on my wish list.
Certainly, at least on the point on greener arbitration, that gained a lot of traction in the past 2 years. So a very rare, I guess, positive upshot from the past 2 years with all the virtual hearings, and I think many of us have experienced the really seamless tech that's available in conducting these sort of remote meetings and remote hearings. Can I also hear from David? What's on your wish list? What changes do you want to see, or alternatively, what changes do you not want to see?
Thank you. I also have 3 things on my wish list, in addition to endorsing everything that Joseph has said. The first is on the transparency point. I would love to see more institutions focus on industry specialist panels. There is this quaint belief in our sector that a good arbitrator can arbitrate anything. That's not true. It's also not true that everybody who claims to be an arbitrator is capable of arbitrating. We don't have sufficient regulation in our sector to protect consumers who select arbitrators. And I think the development of specialist panels will not only help the unsophisticated consumers, but the sophisticated consumers. I have sat on panels where at issue is who owns particular patents embedded in optical transceivers and broadband cables. That's a very difficult question, and having knowledge of the telecom sector, having IP experience is important. In fact, it could be critical to the appropriate outcome of the arbitration. So specialist panels, we've had them historically in maritime and construction. There is no reason we do not have them today in other areas. The industry expertise is even more important, in my view, than legal fluency in sitting in some of these cases. Number 2, I would love to see a more action-oriented, universal commitment to diversity and inclusiveness in our sector. Our sector does not reflect our user population. And I think there's sometimes the quaint belief that diversity is only an issue in Anglo cultures. It's not. I've lived in East Asia. I've lived other places around the world. I have yet to live in an environment where there are not racial or ethnic minorities who are institutionally repressed or otherwise disadvantaged. Including in Hong Kong, for example. So I would like to see a more honest, full spectrum view of diversity, rather than just assuming it's for North America and the UK to worry about. It's really for all of us, and it does not stop and end at gender equity. There are non-majoritarian racial and ethnic groups. There's LGBTQ. There is class disadvantage, and we need to be really looking at that if we want to have a healthy, growing profession. And finally, on a much smaller issue, I see great potential in having appellate arbitration provisions in more bodies of rules. Not mandatory, but optional for parties to select. I think it would diffuse some of the reluctance in some sectors of the new economy to choosing arbitration if parties saw that they were not betting their business on one arbitrator or 3 arbitrators, but that there was a process for appealing within the arbitral system. I've sat in a half dozen appellate arbitrations under 2 particular institutions' bodies of rules, and I found it a very useful addition to the process.
Any final thoughts from Amy or Melody on this last question? Your wish list of things you want to see?
I'll start first. I agree with everything that Joseph and David was talking about, in particular the diversity point. But I think I have one additional wish list or my one. I think international arbitration, by its name and by its nature, it's international. And the New York Convention has done a great job in ensuring that it's international. But using China as an example, I think it is important for all the local courts to be advanced and to build up the infrastructure so as to ensure that whatever awards that you get, you'll be able to actually enforce it somewhere else at the relevant jurisdiction. So it's great to see China having built up that infrastructure. It's great to see some of the other jurisdictions have done so as well. But it would be even better if, you know, the more than 160 jurisdictions in the New York Convention are doing exactly the same thing. So I think it's a rather, I would think it's a not so difficult, hopefully, wish list for mine.
It's really positive, at least when you look at the New York Convention member state list. Every year you see that increase year on year. So as you say, hopefully in the future we'll have like globally all states who would have signed up, and we'll have the seamless, successful enforcement everywhere. Any final thoughts from you, Amy?
Sure, I'd just add one final thought. Courts, of course, are institutions, but also every institution is made of people, individual judges, and is constantly, there's a constant, flow in and out of the court sort of institution in various countries. And picking up where Melody left off, yes, it's wonderful that we have so many countries coming on to the New York Convention, but that's just the beginning. What we really need is sort of a constant exchange, and it's really from both sides. Even very sophisticated, well-known seats of arbitration with hundreds of years of history of enforcing awards, have new judges every single day, and are constantly confronted with the changing landscape. And really, we need to be going out to the judiciaries in other jurisdictions that are newer to arbitration, don't have that track record, and giving them the tools they need, engaging in a dialogue so they understand what we're trying to do in arbitration, how we work. So I really think it's a constant dialogue, and it needs to emanate both from the arbitration community and from the courts, because I think it's only when each side kind of recognizes, hey, we need to actually do something for the other, we need to learn more about them, that we'll see that learning process, and we'll see that learning process extend not only from the traditional established seats of arbitration, but to a lot of new jurisdictions that are joining the arbitration family.
Thank you, Amy. So looking at the time, I think we're coming to a close. I think we covered a lot of ground today and had a very lively, insightful discussion. We touched on what's important for a jurisdiction to be pro-arbitration. We looked at court's role as a parent in helping an arbitration get on its feet. We heard some very interesting Hong Kong cases from Joseph. We also heard some horror stories when things go wrong in enforcement, but we also got tips on what we can bear in mind to try and maximize our chance of getting a successful enforcement. And we've heard our panelists' wish lists on what they hope to see in the future. So thank you very much again to our panelists for sharing those thoughts and comments with us. And thank you to our audience for dialing in for this session. Thank you.
David and Amy, please do not leave yet. I know it's very late in one and very early in another. Sorry, Amy, we didn't realize there was daylight savings. Thank you guys very much. If I could also ask the 3 of you to stay put, and please look over there. David and Amy, could you please look straight into your cameras? They would like to take a group photo, and I've been promised I will not be in it. 1, 2, oh, 3, 2, 1. Smile. You two stay, just keep looking in the camera. Thank you, guys. Thank you very much for a very insightful panel. We had 3 lovely speakers here in Hong Kong. I've got 2, one from Germany, one from California, when I say from, based. Yes, so thank you. David, enjoy the evening. Sleep well. Amy, enjoy your day. My 3 panelists here, have a great evening. Thank you again. For the audience, we've got a 15-minute intermission where we ask you to please, if you're going to go use the restroom, please come back, because I promise you the second panel will be just as interesting as the first. Here I am again, guys. This is me in my role as an MC. Panel 2 will soon start, so once you're ready, please take a seat. Apparently, we can't start until everyone's seated, but if you feel like you have a lot to talk about, save it for questions. So then you give me less work for panel 2. Thank you. Thanks, guys. Oh, this is a much different view. Okay, most of you came back. That is so nice to see. Hopefully more is going to start scooting in later. Well, good afternoon. Welcome back to the second panel for the Generations and Arbitrations Conference, Hong Kong Legal Week edition. What we have again is another hybrid panel, and I have 3 amazing panelists who are on the screen next to us. For Lisa, Baiju, and Patricia, if you see us constantly looking downwards, it's not because we're ignoring you, it's because we've got a TV screen right here, and that's how we could see you. But it's very good to see all of you. Okay, so I'm going to do a quick introduction on what the panel is going to be about. I'm going to have to give you, I have to open up to see what the name is, even though I came up with the name. It was quite long, I could not remember. So panel 2 today is Second Bite at the Apple. Is public policy really only a last line of defense? Now, I'm sure everyone has read the description, so you know exactly what we will be discussing today, or at least hopefully you've come to hear what we will be discussing today. But I thought what might be interesting to know, why did we think of this panel topic in particular? You know, the issue of public policy is quite popular, quite common, but from a Mood Alumni Association perspective, the reason why we looked at it is because, and I'm sure Patricia is going to confirm, although Patricia, if you don't confirm, no need to raise it. In the last 2 decades of the Vis East, or the 3 decades of the Vis Vienna competition, One of the most favorite arguments that teams like to plead in their pleadings, whether it's written or oral, is that the arbitral tribunal must decide this particular way, otherwise this award will be not enforced or set aside for reasons of public policy. Now, as a coach and as a practitioner, I like to go back and tell my students or remind my students that, let's be honest, maybe 1% of all cases in the world will actually, or 1% of all awards will actually be set aside or be not enforced for reasons of public policy. But at the same time, when I was working in-house, I recognized that in the legal team and also my clients, they're also quite gung-ho about this potential argument of a public policy defense. One thing that I had seen quite commonly was in-house lawyers are quite nervous when it comes to the idea of international arbitration because, as we know, generally speaking, in international arbitration, an award stands as is. The courts, when they're looking to enforce or set aside an award, they're not supposed to look into the nitty-gritty, the substance. So we have clients that are constantly worried that, oh my gosh, what happens if the tribunal just got it wrong? Or what happens if something has gone completely against our case? It's so against more morality, Simon's going to elaborate on this, that the award needs to be set aside or not enforced, but it's not a possibility because it's only 1%. Well, today's panel is going to tell you whether or not my advice to my clients and my students are correct. Hopefully it's going to be a mixture of yes, it's both correct and it's wrong. What I would like to emphasize before I introduce the panel is that we really would like today to be an interactive session. I do recognize that it's a little bit difficult because we've got both in-person and online participation, but this is why I have this. Apparently, I have the ability to look at questions and answers on the Zoom, and if I don't, somebody's going to tell me and figure out the question. If you guys in the audience have a question during the panel discussion, please raise your hands and we will be happy to answer and address them. For my panelists that are online, we actually have a much better turnout in person. Apparently, people are starting to get sick of staying home or doing everything online. So I do wish you guys were here to see what a lovely audience we are, but I am also very happy to have you with us. I'm going to do the introduction of the panelists in alphabetical order. I apologize in advance if my information is out of date or if I'm a little bit too personal, but those of you who know me, I'm quite informal and I just like to keep things interesting. So let's start with Dr. Lisa Beisteiner. Lisa is a partner at Seiler Floyd Zadkovich. She is based in Vienna, Austria. Lisa sits both as counsel and arbitrator, and she is quite experienced in cross-border disputes. She's an Austrian qualified lawyer, but she has an extensive amount of experience in arbitrations and litigations, arbitrations worldwide. One thing that I like to comment on about Lisa is, so when I lived in Vienna, Vienna tends to be a very laid-back, kind of easygoing pace of life. And I was always quite shocked when I got out of the office, everything was closed because things close at like 6 p.m., 8 p.m. Things are closed on Sundays because the way of life is really good. But Lisa always amazed me because as a mother, as a partner of a wonderful boutique firm, she was always able to accomplish so much. So she did not live up to the typical Austrian standard, or maybe she does. Don't get me wrong on that. Next, we've got Mr. Simon Chapman, QC, and I love to say the QC. So Simon is a partner and regional head of practice for dispute resolution in Asia with Herbert Smith Freehills here in Hong Kong. I may be wrong, but I remember when I first met Simon almost a decade ago, he was soon promoted to partner, and it was amazing because everyone was telling me how he was one of, if not the youngest partner that had been made up at Herbert Smith Freehills. That shows you how hard of a worker he is. But at the same time, I'm gonna get in trouble. He could definitely drink me under and be perfectly fine the next day. Simon is one of the handful of solicitor Queen's Counsel in Hong Kong. I'm correct about that, right? This came from last year. Very good. And he sits both as counsel, as arbitrator, and Simon is also one of the ICC Court's alternate member for Hong Kong. Next, we have Professor Dr. Patricia Shaughnessy. Patricia is a fully tenured professor at Stockholm University. One thing that I do love to mention, she is the founder of, in my mind, the infamous International Commercial Arbitration Law Program, LLM program, at Stockholm University, and she is the arbitration mom, including my arbitration mom, for hundreds of leading arbitration practitioners worldwide. Patricia, prior to her academic career, was also in private practice, and now she also sits as an independent arbitrator. Patricia is also an alternate member for the ICC court, but for Sweden. Sweden, yes? That's the nod. Okay, good. Now, last but not least, somebody that I have been wanting to meet, but thank you, COVID, I haven't been able to meet him in person yet, but I've heard wonderful things. Mr. Baiju Vasani. Baiju will tell me if I'm completely wrong in pronouncing his name, or your firm name, because Baiju is the partner and co-head of international arbitration at Ivanyan and Partners. I understand, Baiju, you are based in the UK? I tried to get this. Okay, good.
Between London and Moscow.
Can you really go from London to Moscow right now?
With difficulty.
So Baiju leads his team, and this may be a little bit outdated because I did some research, but I understand that you lead a team defending Russia against investment treaty claims that was brought by Ukrainian investors in, oh God, Crimea?
Yeah.
Crimea. Baiju is also a senior fellow of the SOAS, University of London, and he also sits as both counsel and arbitrator. We have an amazing panel discussion for you today, and what I'm going to do is I'm actually going to jump to Baiju to kind of give you a little bit of a background, the historical background of what the New York Convention and model law say, in particular or specifically with respect to the public policy exception.
Sheldon, thank you for that introduction. I would love to meet you too, and thank you to the organizers. I wish I was with you in person. I'm sure Lisa and Patricia feel the same, and hopefully in due course, we will all be back to fully in-person conferences. Public policy is, as Sheldon said when she was in-house, is often raised as my 3-year-old son would say, the zombie of the New York Convention, the model law, and statutes when it comes to enforcement. The idea is it's like an accordion. You worry because what does it actually mean? And if it means whatever the court wants it to mean, then it can stretch. And it can stretch to something that you had not anticipated. It can stretch to something that means you've just spent the last 3 to 5 years arbitrating a fantastic award that actually now, considering the fact that your opponent only has assets in that jurisdiction where you have a public policy issue, you're left with a piece of paper and you don't actually have something with which to enforce. So what I thought I'd do before we get into the discussion of public policy around the world and then potentially the future of public policy is to look at a little bit at a historical background and say, well, where did this come from and what was the idea behind this particular exception to enforcement? In other words, is there something to be gleaned from the travaux of, in particular, the New York Convention that will tell us or give us clues as to what was meant when we say that awards may not be enforced if they are against public policy of one jurisdiction or another. Now, travaux, as you know, the public policy exception is in a treaty. It was in the Geneva Convention of 1927. It's in the New York Convention. It's in the model law, and it is in various statutes. And the way it's interpreted, whether it's in statutes or in treaties, may be different. How a statute is interpreted by a domestic court may be different from how an international treaty may be interpreted by the same court. But I think there's some clues from the travaux. Those of you familiar with the Vienna Convention on the Interpretation of Treaties will know that one looks at the plain language. The plain language simply says public policy and no more. If that is ambiguous, and I would suggest that it could be ambiguous because there are various questions that are raised, well, then one can look at the travaux. And if you look at the travaux, what's interesting to me when I looked at the travaux of the New York Convention is the kind of questions that the various countries were asking as they sat together and tried to establish what does public policy mean. So the first thing I'll set out now, rather than as a punchline, is that they could not agree, right? And that leads us to the fact that we're having a panel in the first place. is, of course, had they agreed and we all knew what public policy means, then all courts would have been like, well, that's what it means, and we wouldn't need to have this discussion. But the fact is they could not really agree as to what it meant. But what was interesting, and I think what will set up my esteemed co-panelists in their discussions and in discussions of how this has been interpreted around the world and how it might be interpreted in the future, is the kind of questions that were raised by the delegate as to the meaning of public policy. And so I'll just raise with you some of the questions that were asked. So the first question was whether public policy should be mandatory or permissive. In other words, whether it should be that the court deciding on it had a strict, almost like a strict liability decision. If it's against public policy, whether international or domestic, it's out. Or whether it's a may decide. In other words, they could overlook it for some reasons. And the answer was ultimately that it's permissive, because you use the word may in the New York Convention, and that follows through in the model law and the statutes. The second question was whether a party had a burden of proof in raising public policy, or whether it was something that could be ex officio by the court. In other words, if the court saw something that it thought was a public policy issue, but the party didn't raise it, could the court raise it sua sponte? And the answer to that was also yes. It's not a burden of proof question, it's a question for the court to determine for itself, because it's a question of public policy. Then there was the question of whether it was incompatible with principles of law rather than simply public policy. So the Geneva Convention I mentioned of 1927 had public policy or principles of law of the domestic state. And potentially those two are different. In public policy, it could be international public policy, principles of law, could be basic principles of law of a domestic claim. Principles of law was done away with. And that's very important, because then that leads to the inference that public policy was meant to be international public policy, or public policy that was of the nature that several states would follow in the public policy sphere, because they did away with the question of principles of law of each domestic state. In other words, that public policy would be literally, I forget how many states there are in the world, or signatories to the New York Convention, but let's say 200 odd different public policy questions around the world. Another one was whether the subject matter of the arbitration could be of the question, or whether it's the award itself. And that seems like splitting hairs, but it's very important that one looks at the difference between whether the award is against public policy, or if the award is fine, just looking at first blush, but if one scratches below the surface and looks at how the award was made and what's underlying the subject matter, whether that's a question. That was something that the Travaux shows that the states were discussing, and they looked at the award very specifically. And when I come on to discussing the English position, that's very important, that they don't scratch below the surface of the award and get into the subject matter, because that it does get into the merits of the dispute. And as we all know, finality is critical, and this is neither New York Convention nor the model law nor any domestic statutes are meant to look at the merits of the dispute. The final points were the obvious ones, which is what's the standard for looking at the public policy exception, and whether it's a manifest standard, or whether it's simply a question of, at some level it breaches public policy. And again, when we look at the courts and how they look at it, at least in the English position, as I'll come on to, there is a clear need, in order for the English courts to overturn a decision, for there to be a direct correlation between public policy and the award in order for something to be overturned. It's not enough for there to be some vague, floating public policy concern in the background. It really has to be a direct and causal link. And the final one, and this one is where I think there is this bogeyman or zombie complex for people, is whether public policy is the same as sort of public order or public law, right? In other words, things like, and this is where I think it merges with arbitrability. And there's a conflation between public policy and arbitrability. And ultimately, I think the best way to leave it, as I pass the floor to co-panelists, is that the delegates ultimately decided to pass the buck. And this is very common in treaties. You have it with the ICSA Convention when it comes to the meaning of investment, where they said, well, look, we can't decide amongst ourselves. And so we have two choices. Either we say, well, we can't decide and there's no treaty, or we stick it in and let courts decide for themselves. And ultimately, they decided on the latter. There is ultimately very little to go on, apart from things like the discretionary power, the fact that public policy is a quite high standard. But as to what public policy is, they left it rather barren, and they left courts to decide. And that's unfortunately why, as Sherlyn said, we get onto a situation where there is some fear that this accordion-like standard can mean that you can go through an arbitration, win, but ultimately not enforce.
So the unfortunate becomes a fortunate thing for us, because this means that we can now sit before you today and give you kind of a background of what we see has happened. Well, let me rephrase that. What my panelists have seen happens in their respective jurisdictions that they're going to discuss in relation to public policy. So, Baiju, thank you for the very good introduction, and it segues straight to Mr. Simon Chapman, who will give us his insights and what he's seen in PRC in Hong Kong.
Thanks, Sherlyn. So two very different jurisdictions, and I'll start with mainland China. China is obviously a signatory to the New York Convention, and so the rules on enforcement and set-aside incorporate the relevant standards from the New York Convention, including the public policy exception. And judges in China don't distinguish between the notion of public policy in the context of enforcement and set-aside. It's the same test in both scenarios. There's no explicit definition of public policy under PRC law, so the concept has been interpreted and elaborated on a case-by-case basis by the Supreme People's Court. Generally, however, it's defined very narrowly. If an award is manifestly, that's that word, manifestly contrary to the principle of law, fundamental interests of society, safety of the country, sovereignty, or social custom, then enforcement may be refused. But what does that mean? Happily, those concepts generally apply only in truly exceptional circumstances. And actually, and this is a thing that surprises lots of people, there are very, very few examples of awards being set aside on public policy grounds in mainland China. It's very rarely invoked. Most awards which are challenged successfully in China are challenged on procedural or due process grounds. For example, where the process followed by the arbitrators was not in accordance with the agreement of the parties, or where the tribunal lacked jurisdiction. I'll give some examples of how this works in just a moment, but before I do that, I should just mention briefly a further safeguard that applies in mainland China in the context of foreign arbitral awards. This is the reporting system, which lots of people may already be familiar with, but in short, if a party takes a foreign award for enforcement before the local courts in China, and if that local court does not want to enforce the award, if it's minded to refuse enforcement on any ground, including public policy, it must refer that decision up the chain and ultimately to the Supreme People's Court. So any decision to refuse enforcement in China will ultimately be reviewed by the highest court in the land. And that does offer some protection, because it ensures that the exceptions under the New York Convention are policed in a uniform manner and that there is some consistency in the overall approach. So how does it work in practice? Well, as I mentioned, I could only find very small number of cases where public policy has actually been invoked in the mainland, particularly cases where it's been invoked successfully. One example is violation of judicial sovereignty. And there's a case from 2009 where the decision of the arbitrators contradicted an earlier judgment from the Chinese court on the same issue. And that award wasn't recognized, it wasn't enforced. The Supreme People's Court held that it was contrary to public policy because it violated judicial sovereignty. But that is actually quite an exceptional case, because there's another example from a few years later where the situation was reversed and where findings in an arbitral award were later contradicted by a decision of the Chinese courts. And in that case, enforcement wasn't refused because there was no violation of judicial sovereignty. The SPC ruled that the award had come first, and so the arbitrators weren't violating judicial sovereignty, and therefore the award couldn't be said to be contrary to public policy. There are other cases where the SPC has also upheld awards where there has been a violation of compulsory Chinese law, such as a requirement that the underlying agreement be registered. That's not contrary to public policy. Equally, it's not enough just to say that the award was unfair or unjust on the merits. Again, that doesn't engage the public policy exception. So the concept is defined very narrowly in China. It's very rarely invoked. And the Chinese courts, particularly the Supreme People's Court, have interpreted and applied the public policy exception in a very limited way. Turning then quickly to Hong Kong, the situation is very similar, in fact, in Hong Kong. Public policy is not defined in the Hong Kong Arbitration Ordinance, but it's always been interpreted very narrowly. In one case in 2009, the then judge in charge of the arbitration list, Justice Anselmo Reyes, said that if the public policy ground is raised, there must be a substantial injustice arising out of the award, which is so shocking to the court's conscience as to render enforcement repugnant. That's the test which has been applied in other more recent cases. I understand the Kenai decision was referred to in the first panel, and that's the test that the court in that case also applied. There's also language from the Court of Final Appeal in Hong Kong to the effect that contrary to public policy really means contrary to the fundamental conceptions of morality and justice. So it's a very high bar. And indeed, Hong Kong judges have always been at pains to point out that public policy is a very different animal to the other grounds for refusing enforcement under the New York Convention. And they've generally been very critical. This goes to the title of this afternoon's panel. They've generally been very critical of attempts by parties to wheel it out on all occasions. That's the language that Neil Kaplan used in a case in 1993 when he was the judge hearing arbitration cases in Hong Kong before he went on to become a very famous arbitrator. So it's very narrowly construed. That's not to say, however, that it's never applied. And I did just want to touch very briefly on one recent case from this year. This is the W versus AW case. Hong Kong judgments in relation to arbitration are all anonymized. It's a bit like alphabet soup. When you're looking at the names, it gets quite confusing. But the first line of that judgment, the very first line of the judgment from Justice Mimi Chan says, this is a highly unusual case. And that's a good place to start because it very much underscores that this is an exception to the general rule. Essential facts to that case, very simple. 2 arbitrations running in parallel, both disputes arising essentially out of the same underlying transaction. It's a situation where one party commences proceedings under one contract and the counterparty sues under a related agreement, starts its own proceeding under a related agreement. Lots of overlap between the 2 cases. The 2 tribunals in those cases are essentially deciding the same issues. The dispute arises out of the same underlying transaction, involves the same parties. But only one of the parties decided to appoint the same arbitrator in both proceedings. So you have parallel arbitrations running with two different tribunals. Only one of the arbitrators on those tribunals is the same. And that's where things went wrong, because when the two awards came out, they were fundamentally inconsistent. The decisions go two completely different ways on a common issue. So the arbitrator who has sat in both cases has decided X in one case and he's decided Y in the other case. And so the Hong Kong court quite rightly says, well, that means something's gone fundamentally wrong with the process, because it would be contrary to basic notions of fairness and justice to enforce the second award. It's completely inconsistent with the first award, even though one of the decision makers was the same in both cases. And he didn't render a dissenting judgment in either of those cases. He just reached completely different conclusions. And I just wanted to read very quickly a passage from the judgment of Madam Justice Mimi Chan, because she sets out this point very neatly. She says, it's of course trite that arbitral awards are final and binding between the parties. In an application to set aside or oppose enforcement, the court doesn't sit on appeal to review the correctness of the award on either the facts or the law. It may be said that Tribunal Number 2 was wrong in law to have ignored the principles of issue estoppel and the findings of the first award, but she says that's not a ground in and of itself to set aside the second award. However, the court is concerned with the structural integrity of the arbitral process and the arbitral award. If there is conduct which is serious or egregious, such that due process is undermined, the court may be concerned whether the award should be enforced or set aside on grounds of public policy. So that's the key test. The court is concerned with the structural integrity of the process, whether something has gone fundamentally wrong, such that it would be against public policy to enforce the award. And in that case, Madam Justice Chan says that it would be contrary to our conceptions of justice to enforce Award 2, and there is substantial injustice arising out of Award 2 by virtue of the findings made which contradicted and are inconsistent with the findings which had already been made by Tribunal 1 on the same issues. She does make clear that she doesn't reach that decision lightly. She says setting aside an award is an undesirable decision to make, but emphasizes nevertheless that fairness and due process underpin the arbitral process. They're prerequisites for enforcement. So it's an interesting case, but it's very much the exception in Hong Kong. The vast majority of public policy challenges in Hong Kong fail, but the court will step in if something has gone seriously wrong with the process, such that it would be unconscionable to order enforcement.
Thank you, Simon, for solidifying what I tell my students and clients. So we see in Hong Kong and also in China, very low likelihood of getting something set aside or not challenged, successfully not enforced due to the public policy prong. But let's turn now to another group of jurisdictions. We're going to turn ourselves to, well, Europe, the Germanic countries, and Lisa will correct me if I'm wrong, but she will touch upon the regions of Austria, Germany, and Switzerland, and let me know whether or not my advice is still key and good.
Thank you very much, Shirley. So I will speak as an Austrian trained lawyer. Austria, that laid back, relaxed country in the heart of Europe. And I will do my best to also give you an idea of what public policy means in Germany and Switzerland. And now let's imagine these three jurisdictions as three students in a classroom. And let's assume that their teacher told them they should curtail the zombie of public policy. So they should strive for minimalist intervention of public policy in the arbitral process. And if you look at Austria and Germany, you would probably say they're good students, they're diligent students, they have above average rates. So it's similar examples of model law jurisdictions which, as a rule, use a public policy exception only very rarely with a lot of caution. But if you compare them to Switzerland, that student excels if the test is curtailing the zombie. It's a nerd. Switzerland is not a model law country, but there's no fundamental differences in substance. And the approach that Switzerland takes to public policy is even more restrictive. And maybe that is one of the reasons why it's among the 5 most preferred seats of arbitration in the last survey. So if we look at how these 3 jurisdictions approach that safety wall for public policy, and I start with Austria, and let me just start by saying that substantive public policy can be raised ex officio, just as arbitrability, and I do agree with Baiju, that there may be the limits may be blurred at some points. Procedural public policy, however, is something that the Austrian courts cannot raise ex officio. Maybe that is an important differentiation. And if we look at substantive public policy, the Austrian Supreme Court, which is the only instance in setting aside proceedings, will only touch an award if the result of the award or the enforcement of that award, if we get to refusal of enforcement, so not the reasoning, if the result of the award violates fundamental principles of the Austrian legal order that comprises constitutional law, including the European Convention, human rights, criminal law, civil law, public law, procedural law, and it does so in a manner which is intolerable. So again, we're using strong words as Simon used, manifest. The public policy exemption protects the Austrian national legal order. It doesn't protect a subjective legal position of a party. It also does not protect the state's national interests. It protects the national legal order against intolerable violations of its fundamental pillars and against the intrusion of totally incompatible foreign principles. And of course that means that public policy is a very narrow concept. It's of course narrower than mandatory law. It's narrower than overriding mandatory provisions, the law de police. It's used sparingly and very restrictive. And German law is very similar, and there may be nuances of difference, but you should know that German and Austrian lawyers do tend to also look over the border to what the other jurisdiction is doing and what the courts of the other jurisdictions are deciding. And the German test is, again, the result of an award would be evidently incompatible, another strong word, with the essential fundamentals of German law. And that means, as the courts say, it violates a norm which affects the fundamentals of German public or economic life, or it is in intolerable contradiction with the German perception of justice. And in both jurisdictions, the courts will at all times affirm that there is no revision au fond, so no revision on the merits, no second bite at the apple. You don't re-examine whether the tribunal got the facts right. You don't re-examine whether the tribunal correctly applied the law. And indeed, pretty much as Simon said, if you are trying to find examples of successful challenges, the very few real cases where a challenge on the grounds of substantive public policy was successful. One very probably widely known case is the application of that's from Austrian case law, the application of an effective interest rate of more than 100% per year, which the court says that violates elementary notions of justice. 26, 35%, that's fine, but if we go to 100%, that's just too much. The Supreme Court could also said it could be a violation if a cost award is orbitantly excessive. It also said it could be a violation if the principle, the legal principle that no one may rely on its own wrongdoings is violated. That could be a violation. And the Supreme Court adjudicates that violations of competition law do breach Austrian public policy, and we'll probably get to that. And if you look at the German case law, just to give you some examples, if you were, public policy is held to be violated, if your word, for instance, results in the debtor paying the same debt twice, or if it forces a party to behave illegally, if it is based on a contract which is against bonus mores, if it orders payment of a gambling debt, if it orders punitive damages, and then there are other examples from the German courts. Violations of competition law is another one. And if you look at these examples, you can already see there are some instances where that national perception of justice kind of transpires. Just think of the punitive damages, which from the German perspective may be something that is foreign. But it's very, very important to be mindful of one thing here, and that these examples do include domestic cases, and that the principle does apply, that the weaker the link of a case to the forum jurisdiction, the stricter will the public policy, the more restrictively the public policy exception will be applied. And when it comes to enforcement, as opposed to setting aside for words, public policy exemption may even be more attenuated, so it may be even used more restrictively. That's to be kept in mind. And then if you look into the case law, there's actually a very long list of unsuccessful attempts. So parties have tried to raise the public policy defense, but have failed. And so that's the background. There is an existent but a rather restrictive use of the public policy defense. Since we're talking about having a second bite at the apple, let me point out two loopholes which you may watch out for if you're looking at Germany and Austria, because they might give you a second bite. And the first one is the notion of arbitrary application of the law, willkürliche Rechtsanwendung. That's a recent development, and it could be seen as ever so slightly opening the door towards a revision form. And the Germans started it, I have to say, the Austrians started following that a couple of years ago only. And the courts say, tribunals make mistakes, they misapply the law, we have to live with that. But we don't live with that if that misapplication passes the threshold of arbitrariness. Then the annulment court will step in. And that could theoretically also be an arbitrary contract interpretation, when that interpretational result is in each respect untenable, and if it has an impact on the decision. So that may give a party some ammunition if it's lost the arbitration, to at least try to have a second fight. The good news is that so far, that is a theory, and it has never been actually operated so as to effectively annul or refuse enforcement of an award. But if you look at the decisions, the court really goes into the details of the tribunal's reasoning, and then concludes and explains why that is not a totally untenable application of the law. And there's a second loophole, potential loophole, I should say. I will just briefly mention it. It's European law. Germany and Austria, as you're aware, are part of the European Union. So as such, European Union law may also be the source of the fundamental principles or pillars of law that can form a member state's public policy. And without going into too much detail at that stage, just as a practice pointer, there is a discussion when it comes to, first and foremost, EU competition law, but EU law more generally, whether in the context of the application of EU law, exceptionally, the annulment court and the enforcement court should do a deep dive and revisit on the merits whether the tribunal got that application of EU law right. And there are, that's a very controversial debate. And I think probably the right answer is it should not. But still, the fact that there is a debate does give a party some ammunition and does or may affect the dynamics in an arbitration with EU law, competition law issues taking center stage. Now, turning to the nerd, turning to Switzerland. Switzerland does not have these loopholes. And I should say upfront one important thing. The Swiss system has two different arbitration systems, one for international arbitration, one for domestic arbitration. So we don't have that infection of the case law with domestic cases that we see in Germany and Austria. But on a very general level, if we look at the test that the Swiss Federal Court applies, it is not only in nuances, but it is a different test. And it says the outcome of the word must be in conflict with essential and widely recognized values, which should form the basis of any legal system. So they're not referring to the Swiss legal system, to Swiss perceptions of justice and morality, but to a narrow core of principles common to all civilized legal nations, looking at a supranational level almost. And as a logical consequence, therefore, for instance, competition law, whether European or Swiss or any other competition law, which may be an overriding mandatory regulation, will not form part of public policy in Switzerland, because the Swiss will say, well, there are different ways of how you can organize your economic system, and some cherish competitions and others don't. And there's also no review of the application of the law, even in very rare instances of arbitrary application of the law. And indeed, if you try to identify examples of successful challenges, they're very, very rare. The ones that I found come from the realm of sports arbitration. One illustration is a case in which a professional football player was banned, unlimited and worldwide, to exercise his profession. And that was held, that ban, that occupational ban, was held to violate his personality rights to a degree contrary to substantive public policy. Another case would be a violation of a res judicata principle. I guess, Simon, you already touched upon a case which kind of is, at least to me, was reminiscent to violations of res judicata. Here, I guess, one could also ask whether that is really a question of substantive public policy, or whether we're already going into a procedural public policy. So very rare examples. I'll stop here. So much for the 3 students from the Germanic-speaking class for now. Thank you.
Thank you, Lisa. So I see some similarities between the jurisdictions. You know, light touch, there needs to be a significant impact, possibly changing the outcome between 2 cases on the same issue, or that the issue against public policy needs to actually affect the award, or sorry, the outcome of the award. So moving on, we're going to go to our next jurisdiction just to see if there's more similarities or more things to discuss. I'm going to turn to Patricia, who will give a bit of a background and key cases on the Nordic countries and the US.
Great, thank you. Then when we speak about the Nordic countries, I should note that Sweden and Finland have almost identical arbitration laws, which are not based on the model law, but they strive to accommodate the same principles and approaches and are interpreted in light of model law. But linguistically and in some details are different, whereas we see Denmark and Norway having the model law. But it really doesn't make a big difference in practice when we're dealing with public policy, because the public policy is going to exist both in the national arbitration laws and, of course, in the implementation of the New York Convention. And I think you'll see that jurisdictions will approach generally the public policy in their role as the seat, looking at a challenge on the basis of public policy, or in their role as an enforcing court under the New York Convention, relatively similarly. The difference, which I think Lisa identified a bit, is that if the connection to the seat involves a public policy, so this was a seat court, and the claim is that some very important mandatory provision of law has been disregarded or improperly dealt with at the seat, the court may be approaching with a more scrutiny than if it were an enforcement. Let me note, I'm getting some echo. Are you all hear me clearly?
We can hear you. We hear a little bit of echo, but you're coming through clear.
Okay, great. So at any rate, but the basic approach is, as the other jurisdictions, that any claim of public policy must be directed to matters which are of great importance, of very much significance in the legal system. And that leads to what is meant by the legal system. In Sweden, the Supreme Court has made it clear that a distinction needs to be made between matters which are internal matters and those which arise in an international context. And it is clearly stated that public policy should be looked at with in an international context rather than a purely Swedish context. And I think we see that reflected in many jurisdictions. So the test which has been articulated is that any claim of public policy must be clearly incompatible with basic principles from an international context. But of course, it is a matter, as the other speakers have pointed out, that each country may be open to looking at this from the context of its perspectives. But one can say safely in the Nordic perspective, it's very restricted. As Lisa indicated, one can make a distinction between procedural public policy and substantive public policy. So if we look at those very few cases where public policy has been the grounds for setting aside an award, then of course, by the nature of it, it should involve a public interest. Indeed, we see that the New York Convention grounds in 5.1, it relate to matters of the private interests of the parties. And then we have the grounds under 2A and 2B relating to public interest. So it's quite important that a public interest is at stake. Now, in Swedish law and Finnish law, the grounds for challenge are in two separate sections. So the grounds for arbitrability and public policy are in a different section than the other grounds when it comes to set aside. And it's interesting to note that the grounds for setting aside on public policy or arbitrability have no time limit. The other grounds for setting aside are subject to a 2-month from the date of the award. And this has been subject to criticism because of issues which may relate to substantive public policy, such as competition law and such, could actually be raised long after the award was issued on a set aside. And of course, it's can have strategic and legal consequences, whether the public policy has been accepted or rejected as a matter of a set aside or an enforcement action in terms of how another court may view that when asked to enforce the award. Now, the couple of cases where we see that the Swedish court has accepted a public policy claim, there are two cases involving matters relating to procedural public policy, which one can, as Lisa pointed out, one could say those could be brought as a matter of not having the opportunity to be treated equally and to adequately present one's case. And they can ask, when does that rise to a public policy objection? And when should the court rule on that? The Swedish court in some earlier jurisprudence seemed to say that the failure to afford a party to present its case violated public policy. And I think in its more recent case law, it's been a bit more nuanced. In the two cases we have where that has been the case, the awards were on their face, seeming to have been the result of sham arbitrations. In the first case involving an effort to try to take out of a bankruptcy estate certain assets in a sham arbitration between two brothers, one who was the bankrupt debtor in a small case. The other was in a case of enforcement of an award that came from Latvia, where the Court of Appeal had ordered enforcement, and it went up to the Supreme Court that sent it back to the Court of Appeal to look more closely, because on its face, the award had indications of things were awry. The Swedish party claimed that it had never received notice. And so apart from the lack of notice, which has been another ground for public policy in a third case, there was also a situation where the Swedish party claimed it had never signed the contract. The contract was from an Estonian company, and the arbitration clause was in an appendix in the Estonian language. The alleged Swedish party was in Thailand for a 2 or 3 month period during that. More concerning, the arbitration was filed 2 weeks after the alleged signing of the contract. It was brought to a sole arbitrator in a very small arbitration institute owned by 3 people, a husband and wife who were police in this little village. And the third owner was a lawyer who was not a member of the bar, who was also the sole appointed arbitrator, who rendered an award within 10 days of the arbitration being commenced, and gave 100% sanctions for the breach of the contract, plus compensation, plus interest. So on its face, the award appeared to be suspicious, and it was sent back to the Court of Appeal that it should investigate these issues, even though not public policy had not actually been raised by the defendant or the alleged debtor respondent in the lower proceedings. So we can see that actually the public policy, which is very restrictively applied in the right cases, is contributing to the legitimacy and the trust and the rule of law that arbitration contributes to. So in those cases, the court seemed to be doing arbitration a favor. But let me note that what is important that the court has noted that the threshold is very high. Importantly, it makes a distinction between matters of strictly internal Swedish matters and those which have an international context and are very important. It's also important to note, as Lisa indicated, that the alleged claim must directly affect the matters at hand, and they cannot be an attenuated connection. And also importantly, the party alleging it must very specifically and substantiate what exactly are the allegations? That, I don't know if anyone has followed the Stasi versus Kazakhstan saga, where the Swedish court refused to set aside on allegations of corruption. In that case, it became quite clear from the court's jurisprudence that the court is not going to go into the fact-finding and decision-making, which is within the deference of the tribunal, that the claims must be quite clear and quite substantiated. But one thing which good arbitrators should do is ensure that if claims are made, that they have in fact engaged in fact-finding and engaged in an analysis, and that should be on the face of the award. And finally, I can note the Swedish court has also made clear that if considering public policy allegations, which have been timely, substantiated, specifically alleged, that it should not go to looking at the award in total, but whether there is some specific part of the award that may now be subject to that public policy claim, and that the decision has probably actually been affected by the improper analysis. And then only that part of the award, if it can be severed out, would then be set aside, and not the entire award. So in the Swedish approach, which one can say, broadly speaking, is Nordic, one would have to look at Danish law, Norwegian law, Finnish law, their specific decisions, if we don't have time for that. It is very, very restricted and used only in cases where it appears on its face that there is a significant matter which would affect the clearly incompatibility with generally accepted principles. And finally, I'm not going to go into the US now. Maybe if we have time, we can go into it because that's broad. But we can go back to 1974 in the Parsons case from the Second Circuit, which in the US courts, it's often kind of the starting point, making it quite clear that in the US approach, that it will also be very restrictively applied, and that it must be that when alleged, that it must actually violate the most basic notions of morality and justice from a broad position. When I say broad position, not some specific misapplication of purely domestic law, but some broader, not actually international, but yet looking at these principles from an American perspective with an international view. So I hope that has given some background. Pass the mic now.
Back to me. And I'm continuing to see the trend of a very, very high threshold. So Baiju, I'm hoping when you discuss the UK and Russia, and if you also want to touch on the US, you're continuing this high threshold.
Yes, thank you, Sheldon. And I'm going to start with England, I guess England and Wales, and then I'll move on to Russia. I suspect that some might think that, oh, Russia has some anomaly. So I'll put that one on sort of the punchline and start with England and Wales. And as you might expect, the New York Convention is part of English law through Section 103(3) of the English Arbitration Act 1996, which has the public policy exception. And like the New York Convention, Sheldon, like Patricia, I'm hearing an echo, but I will continue on the proviso that I can be heard well.
You're heard very well.
Thank you. So I think the key thing to understand from Section 103(3) of the English Arbitration Act is that there is a strong presumption that the award will be enforced, and any public policy defenses that are raised are treated with extreme caution. I want to quote the House of Lords from 1853, because it shows just how far back this concept of public policy goes. And we're talking about it now as to recent cases, but of course, many of these things, under common law at least, go to Victorian times. And it says public policy is that principle of the law which holds that no subject can lawfully do that which has a tendency to be injurious to the public or the public good. So at least for the last 150, 200 years, courts have been grappling with this concept of what is against public policy. So it's not a modern concept. But I think the English position is best described in the case of RBRG Trading versus Sinacor, and that's a Court of Appeal case from 2 or 3 years ago. And there, and I'll just go through certain findings of the Court of Appeal, which set out what its understanding is of this concept of public policy. And the first thing that I thought was very interesting is the notion that, first of all, it's to be interpreted restrictively. And the Court of Appeal says this, that there is always a strong public policy in support of enforcement. So what I think is very interesting is that enforcement is a public policy, right? To see the concept of actually enforcing being part of public policy. And I think that's a very interesting way of looking at it, that the award itself is not outside of the public policy realm, but enforcement of that final award is part and parcel of public policy. And so I like that, looking at it in that way, that's already within the bailiwick of public policy. The second thing that the Court of Appeal said in RBRG was, if the tribunal itself has determined the question, and I heard this from Lisa, heard this from Patricia, that if the tribunal has traversed this ground of illegality or fraud or public policy, as it could be, then the court will not reopen that inquiry. It's not it's not a court of appeal on the question of the merits of this question. The preferred approach is to say the tribunal dealt with it, we won't reopen it, and therefore, unless it touches the award itself, rather than the contract, rather than the facts of the case, we are not going to reopen the question. The third thing I think of interest under English law and RBRG in particular is the fact that, again, I think I heard Patricia say this for this, it may have been Swedish court, but she can correct me if I'm wrong, but public policy is engaged where the issues reflect considerations of international public policy and not just purely domestic public policy. And the way the courts have described it are universal principles of morality rather than considerations that are purely domestic. And the fourth thing, and again, Sherlyn, you called it, because I'm going to repeat what my colleagues have already said, is that there has to be, and I touched on this in my first presentation, an absolutely direct causal connection between the claim sought to be enforced and the illegality in question. So the closer you can get to the award itself, as opposed to the underlying subject matter, as opposed to how that contract came into play, the more likely you are to be able to call a public policy exception under English law. It is, as Patricia was at pains to point out in her presentation, a very, very narrow exception. And that's good because, you know, you think about it in terms of what's going to make this arbitration system we all love something that is adopted as a principal method of dispute resolution around the world. And the answer is certainty. If I know that I win my case and then I'm going to go to any court around the world and they're going to treat it fairly similarly and with fair certainty, then I'm going to go with arbitration and not just, you know, try my luck pulling the bar Vegas style on a litigation in a particular court. And so that's what we want. Now, if I move on to Russia, now you might expect that I'm going to be somewhat down on Russia and say, well, in Russia, it's a bit more of a sort of a potluck. But actually, since 2013, the question has been quite fairly assessed. So we start with something called Letter 156. And this was issued by the Supreme Court to give guidance to the lower courts as to what is the meaning of public policy in the New York Convention, which I should say is directly in Russian law. The application of public policy is also in the Civil Procedure Code in Article 426, Commercial Procedure Code 244, and the Law of International Commercial Arbitration, Article 36.2. The letter 156 gave a few ideas, and again, you're going to hear similar stories, which I think should give us all comfort that even though all these disparate nations are determining these issues potentially separately, they are really singing from the same hymn sheet here. Because the first thing the Russian court says is that assessment of a potential breach of public policy in the process of recognition and enforcement should not result in a review of the merits of the award. That is an instruction from the Supreme Court to the lower courts. The second thing is that the courts are empowered to determine the question even if the party doesn't raise it as an objection themselves. So we discussed this as a sua sponte objection. However, and again, this is something both Lisa and Patricia raised, the party raising the objection does bear the burden of proof to show how exactly, with precision, does their objection to Russian public policy, how does it fit within how Russian law looks at public policy exception, and what will not be accepted. And this is a fourth point. And this one I think is very important because where you get developed systems of law that then look at less developed systems of law and say, well, this norm doesn't exist. In other words, there is nothing within Russian law which says, or that is analogous to this particular question. Well, the Russian court have said, well, that's not enough. The fact that Russian law lacks norms analogous to the norms of foreign law applied is not sufficient for setting this aside under public policy in Russia. And the fifth one, again, it's exceptional cases, and you can't use public policy as a catch-all where that objection would otherwise fall within a different category. In other words, if it would fall within arbitrability, you can't say, I object on arbitrability and in any event public policy, right? It has to be its own ground and standing alone. And I think that's very important because it says, well, if it catches on one of the other prongs, you have to bring your case under one of the other prongs, and you can't use this as a particular catch-all. Now, before I end, I'll just say that in 2019, there was a ruling, it's called Ruling 53, which added on to this particular Supreme Court ruling of 2013. And this, for me, made the public policy ground even narrower. Now, when I read it out, some of you may say, well, this is dangerous because what I'm about to read out could be read as a get-out clause, or for the Monopoly players, and I play Monopoly with my kids, I tend to lose, but where you get the get-out-of-jail card. Now, you could read what I'm about to say as the get-out-of-jail card for the state or state-owned entities. But this is what the Supreme Court said in 2019. Lower courts should refuse recognition and enforcement of arbitral awards on the grounds of public policy only when the two conditions are met. One, the award violates fundamental principles of the Russian economic, political, or legal system, and two, or B, such violation may damage the sovereignty or security of the state, concerns interests of significant social groups, or infringes constitutional rights and freedoms of individuals and legal entities. Now, that does raise concerns for me, because I liked the 2013 iteration. I know we're going to move on to the future, and for me, this definition tends to suggest that the state may have a way of saying, well, this is against political systemic issues. This doesn't have the interest of the security of the state in mind. And a big award, for example, against a big state-owned entity, or the state itself may find itself against public policy. And I have to say that is somewhat of a concern. The original iteration, where I was mirroring what Simon, Lisa, and Patricia said was better, this one seems to me as exactly what people are fearing. So it hasn't yet been fully developed, it hasn't yet been fully followed, but I can see some concern that you're moving on to this, what I would say is get out of jail card for certain entities, for certain matters.
Thank you, Baiju. So I've kind of failed at my job as a moderator because I've been informed I've got less than 3 minutes left. It's probably 2 minutes now. But I think, thank you guys very much, because it was a very extensive and good explanation of how different jurisdictions around the world take a look at the issue of public policy. For fear of getting in trouble, I do actually have a question here, if anybody would like to address. The question is, when certain courts generally rejects application of a certain international law, can you allocate the general rejection to a public policy prevention within that court? Or is there any other possible reason of the rejection? If anybody wants to raise a hand, come answer. They're not going to kick me off.
I think that Baiju said it, finality. The policy of promoting the finality of arbitral awards and enforcing them.
Coming off of finality, one last question, and I promise I'll end whoever's gonna, I promise, one last question. So David Hebner in the last panel basically said, what may be your wish list for the future of arbitration? And listening to everybody's, descriptions of the various jurisdictions on public policy and how it's a very high threshold, with the exception of possibly the latest decision, and that it shouldn't be used to be the second bite of the apple. David suggested that, more parties, more institutions should take into consideration an actual appeal mechanism in arbitration, since clearly we can't necessarily go the public policy route. So could I just get each of your maybe reactions to this? Simon, you're ready.
Wow. Okay, it's a big question, and it's quite controversial. I think a lot of surveys have looked at this specific issue in the past and have said, actually, the majority of users of arbitration don't want an appeal. And it's because of the point Patricia just mentioned about finality. One of the benefits of the process is that you get a final decision. And on some of the monster cases that come up before arbitral tribunals nowadays, it can take years to get a final award, but the award is final. And one of the benefits of the process is that you can then take that award and enforce it. You don't get bound up in appeals and then appeals up to a further higher court after that, such that your arbitration turns into a dispute that lasts for 15, 20 years. So I think actually most users of arbitration don't want it, and on that basis, I think it's unlikely to happen.
Do we have any other takers? Go for it, Baiju.
Yes, thanks, Charlotte.
And then Lisa.
Yeah, so I would agree with Simon absolutely in principle, and that's the reason they turn to arbitration. I would say, however, that one thing that certainly clients of mine have not realized is, for example, when they sign up to the ICC or LCIA rules, they're already denying themselves the right to appeal, because within those rules are provisions that say that they give up their right to appeal. If there is one, they give it up. So, for example, as you know, in the English courts, there is the ability to look at questions of English law before the English court, whether that's right or wrong, almost on an appeal. Under the ICC rules, for example, that's given up. Now, I did have a case where I think the tribunal got it very wrong, and that's of course my view, on a particular issue. And I and my client would have loved to taken that to the court. But because we were under the ICC rules, we were automatically and axiomatically banned from bringing such an appeal process. Had the client put their mind to it at the time they had drafted the clause, I suspect they would have said, well, actually, I would have liked the right to appeal. So while I agree on a general perspective, I also think that there may be cases that would benefit from an appeal. And the common law, of course, and this is something that judges will tell you, the common law benefits from the fact that courts might look at how arbitrators are determining, for example, English law, to say, well, actually, you got it wrong. And we don't want that as a precedent under common law of how the law should be applied. And judges should look at the question of English law, particularly when the arbitrators might not be English law qualified at all, and have set something that then becomes public and becomes potentially part of the common law. So I think there may be a balance that needs to be struck between finality and moving common law, the ability for the party to have an award, and justice itself.
Thank you, Baju. Lisa?
Thank you. Just to add one angle to that discussion, and I very much agree that the typical international user of arbitration would go for finality and not for an appeal mechanism, the typical international user. But let me mention that, and that is an exception which maybe confirms that rule. There is a recent study on the Austrian legal system which looks at domestic arbitration and at the reasons why in domestic cases parties may be hesitant to go for arbitration. One of the main reasons is actually the lack of a second instance, the lack of a second bite of the apple. And that is something which scares away at least that group of potential users. It may reflect on the typical user who does not want to have that second bite, at least in most instances. But it kind of it shows that the picture that we're looking at is not black and white, but there's different shades of gray. And I very much agree with what Baju just said, that there is a balance to be struck.
Yes, Patricia.
Briefly, let me just note that this reminds me a bit of going back more than 10 years ago in the US Supreme Court case of Mattel versus Hall Street, where many companies were putting into their arbitration agreements to allow courts, not on appeal, but on regular set-aside proceedings, to have a more expanded role to look into whether or not there was substantial evidence to support the outcome of the case. And the US Supreme Court basically said, we don't know who's right, that finality or party autonomy should prevail, but we do know it's Congress who decides what the court can do. And if the parties want to have an appeal mechanism, then they can try to set it up within the context of arbitration. ICDR, Arbitration Institute in the US, the AAA, the American Arbitration Association, did set up such appeal rules. I don't have off the top of my head how frequently they've been used in the almost decades since they've existed, but I suspect that they are exceptionally used rather than parties opting into it. I suspect the parties want to appeal after they get an award that they don't like, not when they're contracting.
Thank you, guys. Sorry. So I'm really sorry we couldn't talk about the future. I know everybody was interested, but I think I've taken my time. I would like to thank my amazing panel today. Before people sign off and log off, I have been instructed, Simon, you have to look there. And my three panelists, can you please look at your cameras? Because apparently we're getting pictures taken first. Smile. Oh, 3, 2, and 1. Oh, so you guys still look in the camera. We look there now. Smile. Thank you. Thank you guys again. The three of you online, enjoy the start and rest of your day. It was a pleasure having you. Simon, thank you for coming all the way down. Very good to have you here as well. And thanks to the audience. One last thing to add, because this is the Mood Alumni Association associated with the Vismut. All of you who are interested, please do sign up to act as an arbitrator for the Vienna Vismut or the Hong Kong Vismut. Arbitrator registration has opened. We would love your support. And I think that's it. Have a great day, everyone.